do that, Chairman, could I raise a point of order?
Yes, Deputy O'Callaghan.
The point of order I wish to raise arises in the following circumstances. This bill was introduced in the Dáil on the 24th of October 2016. It went through second stage on the 15th of November 2016. The explanatory memo to the bill said it was being introduced to deal with the consequences of the Court of Appeal's ruling in the case of PTSB against Langan. When the Minister commenced his second stage speech in the debate, he repeated that the reason the bill was being introduced was to deal with unintended consequences of that Court of Appeal decision. I supported this bill at second stage because of the consequences of the Court of Appeal decision and the consequences that would have on litigants. What I learned last week, however, was that on the 17th of November 2016, which was some 2 days after the second stage debate, the Supreme Court issued a determination in the case of PTSB against Langan, stating that the decision of the Court of Appeal in that case could be appealed to the Supreme Court because it involved a matter of general public importance. I think this Select Committee should await the outcome of the Supreme Court appeal. If the Supreme Court allows the appeal in the case of PTSB against Langan, then there will be no necessity to introduce the legislation, since the Court of Appeal decision will have been overturned. The standing order I wish to refer you to, Chairman, is Standing Order 153, which provides that in considering a bill, a standing select or special committee may at any time adjourn, and the Committee of the Whole Dáil may at any time report progress, provided that the necessary motion to this effect has been carried. Any such motion which is deemed by the Chair to be dilatory or obstructive shall not be accepted. And in those circumstances, I propose that this Select Committee should adjourn its consideration of this Court's bill until the Supreme Court has determined the appeal. Before
inviting the Minister to respond, I'd just like to seek clarification in your preamble to your proposition. You indicated that it was said that it could be appealed. Could you advise us if that process has indeed been set in motion?
Yes, it has. The determination, which is, and I hand it up to you there, Chairman, is the determination of the Supreme Court dated the 17th of November 2016, and the Court has determined that there will be an appeal in the matter. The parties to the case, the appellant in the Supreme Court, PTSB, brought an application seeking the permission of the Supreme Court, which is only granted in exceptional circumstances, to hear an appeal from the Court of Appeal decision. And the Supreme Court has ruled that that case will be heard by the Supreme Court, so it will be heard. And in light of the fact that the reason this bill has been introduced is because of the unintended consequences of the Court of Appeal's ruling, I think, out of respect for the Supreme Court, but more importantly for this House, why should we proceed to legislate if it may not be necessary?
Just a final question before inviting the Minister to respond. Have we any indication as to the time frame in terms of its address by the Supreme Court?
Well, the Supreme Court is hearing cases much faster now because of the presence of the Court of Appeal. The decision of the Court of Appeal, as we know, was given in July. The Supreme Court is giving listings for cases within periods, I think, of 6 to 9 months. So it is faster. I can't be definitive on that. But I think we should not proceed with this committee hearing when there is a Supreme Court appeal that is going to be heard in respect to the case that forms the whole reason why we're here.
Deputy O'Callaghan, I'd like to ask Minister Stanton if he would like to reply, please.
Well, I want to thank the Deputy for bringing this to our attention. I wasn't aware of this before this started, unfortunately. At the same time, I think we could possibly proceed with this because it's a very important piece of legislation without prejudice to the Court. There are other stages in this legislation that have to be gone through, and it could be suspended or stopped at any stage. But I think that we can't obviously foresee the outcome of any court hearing, and in the interim, it would be without prejudice that we could actually proceed here with this committee stage, discuss the issues, and then see what happens in the courts. Obviously, it would be up to the Oireachtas at the end of the day as to whether or not this bill would finally pass. there is a lot of uncertainty there, and this is an important piece of legislation with respect to the jurisdiction of the courts, as we've already agreed. So I think we could actually discuss the committee stage amendments here and proceed in that without prejudice. It wouldn't have any impact on, obviously, the court at all, and I think that would be important to do that.
Would you like to respond to the Minister?
I hear what the Minister says. I think we should not proceed with the committee stage here today. If it is the case that the Supreme Court allowed this appeal, then we will not have to introduce this legislation. I think this House should be cautious about introducing legislation which is unnecessary. As well as that, the Supreme Court is determining the matter. We don't want parties in the Supreme Court to say that this has been affected or it has been rendered moot as a result of the bill or legislation being introduced by the Oireachtas. Consequently, I would like to put it to a vote, Chairman, that we should adjourn.
Inviting Deputy Chambers, who is the next to indicate, and Deputy Brophy following. Could I just clarify again, Deputy O'Callaghan, from what you've said, when did you become aware of this? Do I gather from you what you've stated here that you learnt of this last week?
I learnt of it last Friday, and in fact it was reported in a newspaper, it was reported in the Irish Times that the Supreme Court had granted permission to appeal. I then checked the court's register, the website. That's where the determination that I handed up to you, Chairman, just a few moments ago, is available. It's in respect to the case. It talks about that there being an important issue of public importance in the case. That's why there's legislation here. And I think we should just await the outcome of the Supreme Court appeal.
Deputy Chambers.
Thanks, Chair. I'd like to echo what my colleague Deputy O'Callaghan has said. And if you look at what the determination is from the Supreme Court to allow this appeal to be made, they said the court is satisfied that the bank has demonstrated that the decision of the Court of Appeal sought to be appealed against does involve a matter of general public importance, so that the constitutional threshold for granting leave has been met in this case. And they've also said, having regard to the grounds advanced in Section 6 of the bank's application for leave, there is no basis for forming the view that the bank has no reasonable possibility of succeeding on the appeal if leave is granted. Accordingly, leave will be granted. So clearly the thrust of the Minister's speech at second stage was to provide and progress a piece of legislation. And that piece of legislation may be impacted on a Supreme Court determination that will be heard very soon. And as a committee, we have to be cognizant of that when we're discussing something. And the central principle of why you want to progress this has been appealed from the Court of Appeal to Supreme Court. And I think it's important that we await that determination and that we do adjourn as per standing orders, because it has been appealed, and the whole tenet of and principle on which drives this piece of legislation may not be relevant pending the decision of the Supreme Court. And I think that's extremely important. I'd also like to note that I think it is surprising that the Department of Justice didn't make you aware, Minister, of this decision, which is so relevant and central to the piece of legislation that you're actually putting forward here. And I'd have sympathy for you at this. You've been left in a scenario where you're clearly not being briefed on very significant cases that are being widely reported in the media. So I think it's important, in addition to what Deputy O'Callaghan has said, that we adjourn, because clearly there hasn't been full and due consideration given from a departmental perspective to what you're actually trying to progress here today. Thank you.
Chambers.